Some interesting updates in the Donna Adelson and Richard Allen trials. So first, let's talk about the Donna Adelson trial. So by now, everyone has seen the body cam footage of Donna Adelson at the airport getting arrested, having those handcuffs slapped on her hands, and she getting put into a squad car and then taken off to jail. So we all saw that even though she was about to take her one-way ticket to, it just so happens to be a non-extradition country like Vietnam, and the only reason why she didn't book a return flight was because she just didn't know how long she was going to stay there for. I mean, I'm assuming we're going to hear something like that. And she just wanted to stay there for as long as, she really needed to get away from her husband, just to get with her husband, to get away from all of this drama. And she wasn't really sure when she was coming back. But of course, she wasn't running away from anything that was possibly going to happen. And it just so happens to be a non-extradition country. But anyway, all that aside, she was arrested and she was taken away. So the question is there any legal significance besides the fact that she, obviously the consciousness of guilt that she was trying to escape the country, but aside from that, is there any legal significance of anything that happened during the arrest? And the answer really is no. Maybe she shouldn't have spoken as much, but she didn't say that much anyway. But I still have some observations that I'd like to share with you, and you can tell me what you think about my observations. So I'm just going to play for you a small clip when she was first approached by the police officers and they had their first initial conversations. And here we go. Let me show it to you.
Yeah. You're under arrest. Cell phone? No, I don't want to give it to you. Why do I have to? Because my attorney said not to. Why do I have to give it to you? This is evidence. Evidence matters. She's under arrest. I have to go with. I have to go. I have to go. Let me help you out. I have to stay. Please stop this. You need to grab the bags. Take the bags. Yeah. You need to wait outside. Okay.
My husband's almost 80 years old. He can't come with me?
Please, can I go?
No, you can't join me there.
Oh, don't do this, please.
Please.
Oh,
Someone's got to help him get home. This is terrible. You can't do this. This is
Okay, so what's her first response? Her first response when they tell her you are under arrest for the murder of Dan Markel. Her first response is, oh, here we go again. Now, what do you mean, here we go again? She was never charged before. She was never arrested before. What do you mean, here we go again? It almost sounds like she's putting herself in the same boat as Charlie. Almost like we're together in this. And Charlie was just arrested unfairly and he's innocent. And now you're coming to arrest me. Like, here we go again. So you're arresting me the same way you arrested Charlie. And the same way Charlie's innocent, I'm also innocent. But I don't think that that's the smartest approach for her as she's going towards trial. I don't think that she should put herself in the same boat as Charlie. And some people have speculated about what Donna's defense is going to be. I imagine, and this is all complete speculation, but I imagine it's not going to be the double extortion theory that Charlie put up. Obviously that didn't work, and it's a pretty wild, fantastic story, and nobody bought it. So why would Donna go down that same path? So it almost would seem that she should really try to create a distance between herself and Charlie. And I imagine that her defense would sound more like she had no idea what was going on. She just had no idea, and of course she loves her son, and for some reason her son wanted her to make out some checks to his old girlfriend, Katie McBanoa, and that's what she was doing. You're right, I shouldn't have done that, and it was probably illegal, but I had nothing to do with the actual murder. I had nothing to do with the conspiracy of the solicitation to commit this murder. I imagine that that's more of what the defense is going to be. Now, of course, I know that there's evidence against that. She did say, after all, after the bump, she calls Charlie and she said that this probably has something to do with both of us. So yes, I know that there's some evidence, but I just imagine that she's not just going to go for the same defense as Charlie, that this was an extortion and she was really in on it, that she understood that this was all an extortion. And really, it was more about that she was just this poor old grandmother that had no idea what was going on. And yeah, of course, she had some mean words for her son-in-law that was going through a vicious divorce with her own daughter. Yeah, of course, she came up with some crazy ideas. And, I imagine that that's going to be sounding more like what the defense for Donna is going to be. So again, I just feel like here we go again, almost sounds like she's putting herself in the same boat as Charlie, which I would think she should separate herself from Charlie and create a distance. But then again, maybe I'm reading too much into what she said. All right, now let's move on. So then they say, okay, well, too late, you're going to get arrested. Too bad, you're going to get arrested. And then Harvey says, well, I have to go with her. And then Donna says, my husband is 80 years old. He can't come with me? Like, she was shocked. He can't come with me? And then, like, what do you think? Like, where are you going? You're going to jail. What do you want him to do? You want him to sit in the cell with you and to comfort you in jail? Well, what do you think this is? Is that what you think happens in jail? Yeah, of course he can't come with you. This is jail. He doesn't get to go. You don't get to pick a friend to be with you, or a husband, or a wife. So what does that mean? Well, what's the shock? Oh, he can't come with me? And then she does this. She kind of flips the script here, and she says, "Well, someone's got to help him get home. Someone's got to help him get home. This is terrible. You can't do this. This is insane. This is just insane. What's going on here? You're just going to send this 80-year-old man home by himself? This is just insane." So what's she doing here? What she's doing is she's just flipping the script, which is pretty common when a person is acting defensive. When you're sometimes accused of doing something wrong, a lot of times you'll try to turn it on the accuser. You'll say, "Oh, I'm doing something wrong. You're doing something also wrong. You're just as bad as me." Or, "Look what you're doing. You're going to send this 80-year-old man home by himself instead of letting us go home together, I guess, and then arresting me. I don't know." But the point was that she's being charged with the murder of Dan Markel, and now you're worried about this 80-year-old man getting home by himself. So it's just a way, I think it's just like a common psychology thing to flip the script and say how the officers are really being evil and mean, and it's not really just you. All right, well, anyway, so that was some observations with that. But let's get now down into a little bit more of the important updates that are going on with the Donna Adelson trial. And that is that there's been some new attorneys that entered appearances. There's been a substitution of counsel. She was represented by one attorney, and now she's being represented by none other than Dan Rashbaum and another attorney called Alex Morris. Now, Dan Rashbaum, we're familiar with from the Charlie Adelson trial, but who is this Alex Morris attorney? Well, this Alex Morris attorney is a Tallahassee criminal attorney. And I think that this was actually a smart move by the Adelson family to hire a Tallahassee attorney. Why? Because trials are not just about who knows the law better, who is more articulate, who is more charismatic, who just makes a better impression on the jury. It's not just about that. If it would be, then you can have anybody from New York or California or Miami go try a case anywhere. And of course, it's not going to always work because you've got to know your population. You've got to know the city. You've got to know the locale. You've got to know what's important to them, what speaks to them. You have to know how they tick. So it's important to know the people that you're going to be speaking to, the jury, and be able to, and understand how to relate to them. They're not always going to appreciate these big city attorneys. So you have a place like Tallahassee, you got to really know. And a lot of times, some good experienced attorneys, before they go and try a case in a jurisdiction that they're not familiar with, they'll actually go down there and scout it out beforehand. They'll sit in the coffee shops. They'll sit at the pancake houses, and they'll see, what are people talking about? What news are they reading? What's going on in the local town? Is there some big high school football game going on? Who's the local heroes? And you want to know about that so that when you're coming to trial, you can relate to this jury. And in fact, I know there's been cases like that where an attorney will come into the city, he'll learn about it, and then he'll be able to use some information that he's learned about the city and about what's important to those people, and use that in his opening statements or closing arguments, or use it as an example, and it will really score him a lot of points. So as we know, a jury trial is not just about how well you know the law, how well you know the facts, how well you can argue, but it's also connecting to the jury. You've got to connect to the jury. And when you're in a place like Tallahassee, which is very different than Miami, a Miami attorney is not always going to do the best job for you. So the fact that they got this Alex Morris, who's this Tallahassee attorney, is certainly a step in the right direction for them, that you have somebody here who is with boots on the ground who can kind of speak the same language as the people that are going to be sitting on the jury. So that actually was a good move. Now, some people have asked me, do I feel that something that Dan Rashbaum should have done, should have argued something else? Should there have been a different theory in the defense's case, or could anything could have been done differently in Charlie Adelson's case that would have given him a better chance of success? And again, I don't know. You have to really do a deep dive in all the evidence, and you really have to make sure that whatever theory you're going to try to come up with, there's not going to be some obvious weaknesses that can be argued back. But I want to throw out an idea to all my intelligent viewers and see what you have to think, what you have to say about this idea. I was just thinking like this. We know that Dan Rashbaum in his opening statement, that's when he said his theory about the case. He said that this is really a double extortion, and he let the jury know from the get-go what the theory of the case was. And what that did was that kind of put the prosecution, gave the prosecution the ability and gave them the chance to now work on rebutting that the entire trial. And they were able to now bring that out in all the different witnesses. They tried to, especially we all remember with Wendy. When Wendy got on the stand, right away, the prosecutor asked, "Whoa, did you just find out that your brother actually knew who murdered your ex-husband? And you didn't know about it?" And she kind of, poked holes in it, and it really rebutted this whole argument the entire trial. So then by the time closing arguments come, the jury already has heard how weak this double extortion theory is. And as an attorney when your theory is strong or weak. And this was one of those theories that it's a shot in the dark. And if you're giving the prosecution that entire time to be able to attack it throughout the entire trial and think about it and go home after trial and go back to the office and try to figure out how we're going to dismantle this whole theory, then it's giving them more, it's not something that you want to do. So I was just thinking that maybe it would have been a better approach by the defense attorney. And maybe you can tell me what you think about this. Maybe not to mention the theory in opening statements. Don't mention it at all. After all, the defense doesn't have to give any theory in the case. The prosecution has the burden to prove the case beyond a reasonable doubt. The defense doesn't have to say a word. So the defense really can spend the entire trial trying to poke holes in the prosecution's case, and then finally at the end, call Charlie Adelson, and that's the first time that the jury will hear the truth. And once the jury will hear the truth from Charlie, and then, okay, maybe the prosecution is going to try to rebut that with certain rebuttal witnesses, but then at least by that time, you wouldn't have spent 3 weeks of the prosecution trying whatever they can to dismantle this theory. And then they'll have a much shorter time to dismantle it, and you might have a better chance of the jury buying it. Also, think about it. The jury also has all this time to think about this theory. And when they're hearing the evidence, they can continuously be thinking about this theory in their heads. So they also have a lot of time to think about this theory and decide whether it makes sense or not. And you don't want to give them a lot of time because this is a weak theory. So it would be much better probably is if you save your theory to the end of the case, let the prosecution try to call whatever rebuttal witnesses they can. Maybe they'll try one or two. They're not going to, maybe they'll recall Katie McBanawith and say, no, this wasn't a double extortion. But they're not going to be able to put on their entire case again. So it'll be much faster, and it'll catch them much more off guard. So maybe that would be a better approach in the Charlie Adelson case. And perhaps, maybe that would be a better approach also in the Donna Adelson trial. We don't know what the theory is going to be. But maybe also, again, let the prosecution put on their case. As the defense, you try to poke holes in it as much as you can. And then spring your theory on them at the end of the case and argue that in closing arguments. And then maybe you'll have a better chance of success in that case. But again, like we said, we don't know what's going to happen. The evidence is they have some pretty strong evidence against Donna, and they're going to have to come up with something. And like I said, I imagine it's probably going to be somewhere along the lines that she really had no idea what was going on, and she was just listening to her son, doing what her son tells her to do, give her money, whatever. So that's just my thoughts about that. So let me move on to the Delphi murder case. This really tragic murder case of these two young girls. And they're pinning it right now on Richard Allen. Richard Allen is the defendant. And what happened, just to catch you up, if you haven't seen my analysis on that case, you got to check that out because it sets the stage for what just happened recently this past week or last week. So just to give you a short synopsis, Richard Allen had two attorneys, Baldwin and Rozzi. And there was a gag order entered into, and at some point, they left their conference room open, and somebody came in and took some pictures and then disseminated the pictures, and it was all over the place, and there was a problem. So the judge, who's a special judge who was assigned just for this case, this special judge had a special conference with these attorneys. And this was also where you had the courtroom, which was essentially closed to cameras. She didn't allow any cameras in there, no videos in there. Everything was sealed. And for this specific date that she was saying we're going to have a hearing, she invited all the camera people, all the TV people to come in. And then she has a session she has a meeting in her chambers with the attorneys. And she tells Baldwin and Razi that she has a prepared statement to make in open court with all the cameras on, and she's basically going to say how she feels that Baldwin and Razi are just completely incompetent, and they committed gross negligence, and basically just completely destroy them in front of everyone. And that's their choice. They can either let her do that, or they can voluntarily withdraw from the case. Now, obviously, what they did was they voluntarily withdrew from the case, and there was a transcript of that meeting in the judge's chambers. And because of that, they eventually later they withdrew, and then they filed a motion to get reinstated as the attorneys for Richard Allen, because Richard Allen wanted them as attorneys. And then they also felt afterwards like, hey, our due process was completely violated then. How can you just threaten us with public humiliation, and that's how you're going to get us to withdraw from the case? It just reeks of due process violations. So they said, no, we're going to come back onto the case, and we don't care if this gets out. And the judge, even though they already had other attorneys assigned, and they were just going to work with Richard Allen pro bono, the judge says, no, we're not allowing you in the case, because she felt that what they did was gross negligence. It was gross negligence, and therefore they are ineffective counsel, and they cannot represent Richard Allen anymore. Well, Baldwin and Razi filed a writ of mandamus, with the Supreme Court of Indiana, requesting three things. They requested, number one, that they be allowed to be reinstated as Richard Allen's attorneys. Richard Allen wants them as his attorneys, and the judge is not allowing them to represent him, and this is a Sixth Amendment violation. Sixth Amendment violation that you should be able to have the counsel of your choosing. So that was number one. They asked we should be reinstated as their counsel. Number two, they asked that the trial court should remove this new special judge and assign it to a different judge, because this judge herself is very obviously biased and prejudiced against these two attorneys, and it's not going to be a fair trial. That was the second thing that they asked for. Now, the third thing they asked for is that they want a speedy trial. That's also another guaranteed right. So they want a speedy trial. They want the trial to be set within 70 days of when this writ was supposed to be granted. So the Indiana Supreme Court just filed an order, and in this order, they said, we're going to grant you one out of those three requests. One out of those three requests you're going to get. And the one request that we're going to grant is that the attorneys get reinstated as the attorneys. But the other two things, we are denying. We're denying all other relief. So which means that the same judge is going to be there, and it doesn't have to be that the trial is going to be within 70 days. All right. So, and they say also that the court is going to promptly, this is the Supreme Court, the Indiana Supreme Court is going to promptly issue a written opinion explaining its reasons. So that's what we have here. At some time in the near future, we're going to have the whole entire opinion and giving the entire legal analysis behind their decisions. But let's just think about what we have right now. What we have right now is we have two attorneys that are going to be practicing, that are going to be representing Richard Allen in front of this judge who has openly told them that she feels that they're grossly negligent, they're incompetent, and that they can't even provide effective assistance of counsel. So that's this judge's opinion of these two attorneys. And these two attorneys obviously don't have such a high opinion of this judge. And they're supposed to be having a trial now together. Now, aside from all the tension and anxiety and stress that go into a regular trial of this type of crazy murder trial, but now you're also going to have the additional drama and tension of a judge and these attorneys who can't stand each other. So can you imagine what the tension is going to be like in that courtroom? It's going to be pretty crazy. So certainly just imagine if they make objections. Imagine if they make motions. You think that the judge is going to take them seriously now? Doesn't sound like she has a high opinion of them. So I am sure that the attorneys are going to feel the entire trial that their client is not getting a fair trial. So we are going to see all of this tension play out during this trial, unless something changes. But if it stays the way it is, and the same judge is on the case, and these two attorneys are trying the case, it is going to be really, really interesting. So definitely a trial that you're going to be wanting to watch, certainly now. So that will be it for today, and thank you all for watching. If you haven't yet subscribed, please like, and we will see you next time.